is going to call 2022 CR 3521, State of Texas versus Armando De La Rosa. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the defense?
You're not gonna for the defense, Judge.
And are you Mr. De La Rosa? All right, Mr. De La Rosa, you entered a plea to count one on May 9th. That was a plea of no contest. You applied for deferred adjudication. The court found there was sufficient evidence to find you guilty. The state waived count two in the repeater paragraph. According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. The state opposes your application, and they are taking two cases into consideration. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Your Honor.
All right, any objections to the PSI report from the state?
None from the state.
Defense, any objections to the PSI report?
Just one part, Judge. When we're talking about gang affiliation, I spoke with my client about it. They still have him with the Hermanos Pistoleros. He claims he has not been with that gang for quite some time, that he's been trying to get that, I guess, fixed over at the jail. They're still ranking him as that, but he's saying he is not associated. So other than that, that's it.
All right, state, do you have any witnesses?
We don't, Judge.
Defense, do you have any witnesses?
Just argument.
All right, then state you're opposed. The court will hear argument.
We are, Judge. Judge, I think in this particular case, my understanding is the plea agreement was we're asking for 10 years and he's applying for probation and we're opposed, correct, Judge?
Yes, he's applying for deferred adjudication and also community supervision, if not deferred adjudication.
Understood. Judge, I think the biggest thing is dating back to 1994, Mr. De La Rosa has he has 18 arrests resulting in 11 felony convictions. He's been placed on community supervision 5 times. He's been revoked 4 of those times. He's been in and out of prison, it looks like, for his entire adult life. This is a case where I think that he has been in the system for so long that I don't think he's a good candidate for probation. Other judges have taken chances on him on probation, and it seems as though every time he has been revoked for those probations. In addition, there is 3 cases he's here for, 3 felony cases. 2 of them are being TIC. He's received the benefit of the bargain in this particular case with us lowering his exposure to 10 years. We'd ask that you sentence him to 10 years and you deny his applications for probation or deferred.
All right, defense.
Judge, although there is no dispute that my client has a long criminal history, as you see in the PSI, he also had a very difficult childhood. Drugs seem to be the main problem here. He has come to terms with his addiction. He understands that he needs treatment. While he's been incarcerated, Judge, he has been very, very proactive, and not only Narcotics Anonymous, trying to get a referral for Haven for Hope, but he has a slew of, more certificates than I've ever seen any client hand me. I'm going to show them real quick to the state judge, because I'd like to offer them to the court for review.
The Gatorade never left the building.
And neither did the person.
Okay.
Yes. All right, so these are not being offered into evidence. It's just for the court to review.
Correct, Judge.
We have no objection.
He's expressed to me that I'm still waiting for him. If he were to get out, he's ready for treatment. He understands that he's not going to get away from this lifestyle without treatment. I've expressed to him, and I've gone through the Taffy Val saying that SADF is what is being requested. He's asking for a chance to go through lifetime, Judge, but understands that if he needs to do SADF, that is what needs to happen. And he also wanted to address it.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Could you state your name for the record? All right, what would you like to say to the court?
I know that my history is very, very long of criminal activities. I've been addicted to drugs since I was 10 years old now. I've been fighting my addiction for a long time due to traumatic stuff that I had when I was little. The girl that we're looking for when I was picked up. We're looking for her in the farm with us. She left me the backpack.
She left you a backpack and she left you digital scales? And she left you digital scales. That's what you're telling me.
And I'm trying to, when we put them in the trunk now. And that's exactly what happened.
You put digital scales in the trunk?
Yeah, because I didn't want to, they're not mine. So I was
Okay.
getting rid of them out of my motel room because I was trying to do me.
All right. Any questions, defense?
No questions, Judge.
State, any questions?
No, Judge.
Just a little argument.
All right, the court will hear argument. I've heard the argument from the state. What is your argument?
Judge, and I know we've just gone through extensively his criminal history. A lot of these cases were sentenced at the same time. I expect what happened was he was potentially on probation, maybe picked up other charges, and they were all consolidated together. Sometimes it takes an individual hitting rock bottom before they start to try to claw their way back up, Judge. I would just point again to my client's actions while he's been in custody. He didn't just sit there feeling sorry for himself. He has started to try to get treatment to counteract the effect that amphetamine is having on his life. He is ready to do treatment, Judge. If this honorable court molested him with probation, he'd be ready to go straight, stay in custody and go straight to SADF, Judge. I believe that only through treatment will we break this cycle of him being recharged and incarcerated.
All right. Mr. De La Rosa, I'm not going to grant you deferred adjudication. I'm going to find you guilty. They do have a therapeutic community at the prison. What I can tell you is therapeutic community will not extend your time at the prison. If I were to sentence you to 10 years, you're not going to be extended more than 10 years because you decided to be in therapeutic community. I have no authority to force them to place you in a therapeutic community, so you'll have to ask for it. You understand? So would you like to be placed in the therapeutic community? All right. So I'm going to find you guilty, sentence you to a $1,500 fine, time and money to run concurrent, taking consideration 2022 CR 2011 and 2022 CR 2012. I'm going to ask that you be placed in the therapeutic community. Would either party like to argue with regards to, well, I guess the agreement was for 10 years. All right. And I'll send you to 10 years in the prison and give you credit for any time served. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? And because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you, Mr. De La Rosa.
Number 2017 CR 0276.
All right, defense, have you had a chance to review that document with your client?
Yes.
Do you have any objections to the oral amendment? Mr. Jackson, the state is asking that there be a supplemental change made to your motion to enter adjudication of guilt and revoke community supervision and cause number 2014 CR 1810W. They're asking that violation of condition number 5 and the state's motion to supplement pending motion to revoke probation and cause number 2017 CR 0276 be added to 2014 CR 1810W. Do you understand?
Yes, ma'am.
All right. Do you have any objections to the state's motion? Defense, are you waiving your time to prepare?
Yes, we are, Judge.
All right. Then, Mr. Jackson, in each of the cause numbers, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it? Are you the same Jim Alfred Jackson in 2017 CR 0276 who was placed on probation for the offense of assault felony second on February 21st, 2017 for a term of 5 years? Is that you?
That's me.
And are you the same Jim Alfred Jackson who's placed on deferred adjudication in 2014 CR 1810W for the offense of assault felony second on April 28, 2014 for a period of 4 years? Is there any objection to the state reading the same allegation once for each motion defense? All right, and that your client's answer to that allegation will go towards both motions?
Yes.
No objection?
No objection.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant Jim Alfred Jackson did then and there fail to report in person or through virtual means, i.e. Zoom, for the months of March, April, May, June, July, August, September, October, November, and December 2020, January, February, March, April, May, June, July, August, September, October, November, December 2021, and January 2022 in violation of condition number 5.
How do you plead to that allegation in each motion? True or not true? State,
State would waive and abandon the remaining allegations of each cause.
any objections to the state's waivers? Excuse me. Do you understand by pleading true to violation of condition number 5 in 2014 CR 1810W, the court could find it true, find you guilty, and sentence you up to 10 years in prison? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. And let me just pull this just so you know that. And did you understand by pleading true to violation of condition number 5 in 2017 CR 0276, the court could find it true, grant the motion, and sentence you up to 6 years imprisonment and up to a $1,500 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 5 in each of the motions? Court will find violation of condition number 5 true in each of the motions. Is there an agreement?
Yes, Your Honor. In 2014 CR 1810W, the agreement to grant the state's motion to enter adjudication of guilt and assess punishment of 2 years confinement in the Texas Department of Criminal Justice Institutional Division. There be affirmative finding of family violence and it run concurrent with the other cause number. And then in 2017 CR 0276, the agreement to grant the state's motion and reform the underlying sentence to assess punishment of 2 years confinement in the Texas Department of Criminal Justice Institutional Division. There be an affirmative finding of family violence, and that cause run concurrent with the 2014 case.
All right, Mr. Jackson, is that your agreement?
Yes, ma'am.
Defense, is that the agreement?
It is our agreement, Your Honor, we ask that he should receive credit for all time that he served under this lawsuit.
Okay, I'm having a hard time hearing you, counsel. Are you whispering, testing my hearing? Brennan, were you able to hear what he said?
He's talking very low.
That is our agreement. We'd ask you to grant credit for all time served under those clause numbers as well.
All right, Mr. Jackson, are you asking the court to follow that agreement? Are you waiving your right to appeal?
Yes.
All right. And cause number 2014 CR 1810W, the court will follow your agreement, sentence you to 2 years in the prison. There's an affirmative finding of family violence. This will run concurrent with 2017 CR 0276. There's to be no contact with Asteria, Asteria Solana, Solana. There's $1,000 fine. Time and money are to run concurrent. Is there anything else from either side with regards to sentencing in that cause number?
Nothing further from the state.
Judge, from the defense, my client informed me that he and that young lady just had a child. We'd like to request the court to change the no contract to no harmful injurious contact.
I believe as an original condition of his probation, it was no contact. So that's something you'll have to handle somewhere else. And the fact that if there was a no contact order in place, and somebody can research and tell me whether there's not, the fact that you're having another baby with her tells me there was contact.
He's telling me that it was a no harmful or injurious contact.
All right, let me see who did let me check. Someone else took the plea. Does anyone know if it was to be no contact?
I'm looking here.
Thank you.
under clause number 2014 CR 1810W. On the original conditions, it's no contact.
Yes. And that's what I have in the conditions that I'm seeing. It says, number 27, no contact order, general order, you will neither contact nor attempt to contact Estonia Solana, nor any of his or her family members in person, verbally, and so on and so on. So you have to take that up with someone else.
Your Honor, may I?
Yes,
Under the other clause number 2017 CR 0276, it says the same thing.
all right, thank you. So there's no contact in both cases. All right, then in 2017 CR 0276, the court will follow your agreement. Just one moment. All right, I'm so sorry. In 2014 CR 1810W, that's the deferred adjudication case. So in that case, I'm finding you guilty, not granting you community supervision, going to revoke and sentence you to 2 years in the prison. There's an affirmative finding of family violence to run concurrent with 2017 CR 0276. No contact with Asteria Solana, $1,000 fine, time and money to run concurrent. In 2017 CR 0276, the court will follow your agreement. The court will sentence you to 2 years in the prison. There's an affirmative finding of family violence. This is run concurrent with 2014 CR 1810W. There's a $1,500 fine, time and money to run concurrent. There's to be no contact with Asteria Solana. Is there anything else from either side with regards to sentencing in that cause number?
Nothing further from the state.
Judge, did you grant credit for time served or is that?
Oh, I'm so sorry. And credit for time served, of course, in each of the cause numbers.
Thank you, Judge.
You're welcome.
Thank
Just one moment. You're welcome. In each of the cause numbers, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is felony conviction in each of these cause numbers, you're not allowed to own or possess any weapons or ammunition. And also because there's an affirmative finding of family violence in each of the cause numbers, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. We're off the record. So you want to explain to me why you were not reporting?
The reason why I didn't report after I had found it out, it was a pandemic. That's why I wasn't reporting.
That's no excuse. But I mean, I understand what you're saying, but that's not an excuse. And the fact that each one of these cause numbers has the same complainant, that's an issue. So obviously you have issues. You can't control your anger. And maybe that relationship isn't for you because it seems the only thing you're doing is creating children with her. And you're bringing children into your violent world, and that's not a place they should be. You understand? All right, good luck to you.